SJC-10343, Smith versus the Justices of the Hampden Probate and Family Court.
Say Sue.
Good morning, Mr. Benjamin.
Good morning, and may it please the court, I am Peter Benjamin, John Reinstein, co-counsel with me. This appeal comes to you from a decision of the single justice who concluded that an earlier version of a protocol used in the Hampden Division of the Probate and Family Court for communication with the Department of Children and Families violated the due process rights of litigants. He ordered that the telephone report forms which were used in the court be made available to litigants, at least in ex parte proceedings. However, he declined to rule on the validity of the current protocol for such communications, holding that the plaintiffs lacked standing to challenge the current protocol.
That's a 2007 protocol?
Yes, Your Honor.
Mr. Benjamin, at the time you filed this suit in 2006, and then in November of 2006 filed your motion to certify the class, it's not at all clear to me that the two named plaintiffs were parties to any proceedings in the Probate and Family Court. Is that correct?
They were,
There
were no, I don't believe there were active proceedings at that time. One of the named plaintiffs, Ms. Smith, was a frequent litigant in that court.
She had been, but there's
been.
no indication that she was in 2006.
No, and Ms. Brantley the same. But of course, these were cases involving child custody, which can be back in court at any time.
But you don't, I didn't see anything in the amended complaint that suggested they would be back in, I'm just wondering how, even at that time, they could be representatives of any class.
Well, because they had been subjected to the protocol.
But you weren't seeking relief in their cases, and you're seeking declaratory and injunctive relief prospectively, correct?
We were not seeking relief, and I think the justices, through the Attorney General, have sought to, in some ways, characterize this as being about relief in their individual cases, and it is not. It is about an unlawful practice which was applied to them. And the central elements of the practice which were being challenged, which were applied to them, which were part of the protocol when they filed this case, and which remain today.
Now, what is the practice in comparable cases in Suffolk, Middlesex?
There is nothing on the record on that, Your Honor, and frankly, I don't know.
Well, surely, we now have the 2007 protocol promulgated, correct?
No.
No, Your Honor.
It wasn't.
No, Your Honor. In response to the single justice's order that he concluded that this was a rule of procedure which ought to be submitted to this court, and ordered a proposed rule to be submitted.
No, I understand that, but hadn't the Probate and Family Court promulgated it?
No, Your Honor. They submitted a proposed standing order
does it apply?
Comment and never promulgated
okay, so
it.
Forget about that. But did they, whatever the Probate and Family Court was proposing, and whatever the status, were they proposing it only for this county?
What they were proposing what they proposed in 2007, no, would have been a statewide practice, but it has not been promulgated.
And what is happening on the ground today?
As far as we have been informed by the Attorney General at some time ago, and Mr. Porter may be able to respond to that, we were informed that there was no intention to pursue that standing order.
That's different. I can ask him, but do you not know whether when you go in for these cases now, whether somebody is calling up DCF and getting a oral report and putting it down on a piece of paper?
I know, Your Honor, when you go in Hampden, they are doing it.
So regardless of whether the 2007 protocol has or hasn't gone through the rules and so on and so forth, they're doing it.
They're doing it in Hampden. I took your question to be about Suffolk and other counties, and there I don't have any knowledge. They are doing it in Hampden.
Pursuant to what? This unpromulgated?
Pursuant to the so-called 2007 protocol, or the current protocol, the most recent.
Posted in the Hampden court,
In
right?
the Hampden court, yes.
And is there any case in the Hampden courts whereby this protocol would be appropriate because of the particular circumstances of that case?
I don't think so. Our position is no, that if the court has a belief that it requires additional information in order to make a decision, and of course we respect the notion that the judges are dealing with very important issues and they want to get it right, it has authorized means to do that. It can order an investigation by the probate court. It can appoint a guardian ad litem. There are things it can do. But that is subject to certain protections, such as the opportunity to cross-examine the people who actually then are gaining firsthand knowledge. There is no appropriate time for this game of telephone communication
Doesn't that
to be
usually
played.
occur during emergency, the temporary custody proceedings only? Wasn't that confined to those situations?
Under the current protocol, it is confined to temporary, except in the case of guardianship proceedings where it is not confined to temporary. But by and large, yes, it is. And that still is not appropriate.
Well, excuse me, Mr. Benjamin. What I have here is your reply brief that says petitioners have never argued that hearsay cannot be used in the consideration of temporary motions, right?
Right.
And so you're saying that the only so you would confine hearsay to the temporary motions, and then you would say, but they are insufficient indicia of reliability here.
That's right. There are more reliable forms of hearsay. There are ways of bringing in actual records of DCF under appropriate procedures. We certainly recognize that, for example, in preliminary injunction hearings, affidavits are appropriate. We're not dealing with sworn statements here. We're dealing with third-hand information that is subject to distortion, selection.
So the judge gets this information, is having an emergency custody proceeding, and simply says, "Okay, you've all seen this report. What's the story here? Is there any truth to this? Did this happen? Did that happen?" I mean, the judge can't even use it as a basis to ask some questions of the individuals involved in the proceeding?
Well, I would suggest in other cases that come before the courts, I mean, the judges, our system is one in which judges decide, in general, decide cases on what the litigants bring before the court.
But the child is the one who's got the interest here, right? But it's the principal interest, not the only interest.
In cases where DCF has not been involved, the courts have to make these determinations.
So you're saying the judge couldn't even use this to simply ask questions. The parties might agree, yes, that did happen, that is the posture of the case, and somehow that would still be a violation of some principle.
I think there's an inherent problem in that information coming in the way it is, that it is, despite the best efforts of judges to limit it to this sort of question-provoking function, it's inevitably going to play a role.
I take it that one of your critical concerns is there's a DCF person who goes through the DCF file, right? May not actually be the social worker responsible for that. Pulls out certain information, transmits that to the probation officer, who doesn't know what's in the DCF file. So let's assume that there are 10 pieces of information. 2 say the mother hasn't shown up for the appointment with the doctor, and 8 that say she's shown up with the appointment with the doctor. DCF worker, I'm just saying hypothetically, says to the probation officer, big problem here, mother didn't show up for 2 appointments. Probation officer writes that down, counsel gets to see it. Sounds like there were 2 appointments, and the mother showed up for none.
Right.
Reasonable inference for judge to draw, mother doesn't show up for medical appointments. In point of fact, for the overwhelming number of medical appointments, she has shown up. She's missed 2, and you would like to be able to question her why she missed those 2. I take it that's your real concern. Not that you can't question about what's in, but what's out, what's been selected, and there's nobody there who can tell the judge how selective is this.
I think you've stated that better than I could,
Well,
Your Honor.
doesn't the protocol give counsel an opportunity to rebut whatever, to see the information and then rebut it?
But you don't see the file, correct? You
you
only
don't-
see the report of, am I correct? You only see the report of the 2 incidents?
The only thing that you see is whatever the probation officer has chosen to put down on that piece of
Yeah, but-
paper.
You see exactly what the judge sees, though, don't you?
You do see it, and you see it, yes. You
Yeah,
see
that's
it.
what I don't understand about the briefs here. It seems to me both parties are acting as if the probation officer needs to testify, but he's not the problem, it seems
No,
to
they
me.
don't. They-
Your-
He knows
Your Honor,
nothing
we-
about the underlying
If I
information.
may, we've never contended that the probation officer's testimony is of any value. The probation
isn't.
officer
I
has
mean,
no
he's just-
firsthand
he's
knowledge.
just a-
The justices have suggested that we make that argument. We don't make that argument.
You would, I take it, you would also say that it may be that the DCF worker who was on the other end of the phone isn't appropriate either, because all that person is doing is reading what's in front of him or her.
Exactly, Your Honor.
I take it there is an additional phone. If you go back to my hypothetical, in fact, it turns out that the DCF officer says 10 appointments, she went to 8, she missed 2. Probation officer writes down missed 2.
There are.
I mean,
it
so
is-
that's your triple
Yes,
hearsay.
and we use this analogy in the brief. I mean, it's like the children's game of telephone, where things are communicated by one person to the next and to the next.
What's the solution here, Mr.
Is the solution
Benjamin?
that you get the folder, that the folder be made available?
I think that, I mean, there are a number of possible solutions that
That
the
may
actual...
be problematic, right? That's really problematic.
Well,
Yes.
I think that the solution is that if, you know, that the people who have firsthand knowledge be in court to testify.
But how do you deal with your client is coming in for an emergency custody thing? Getting people with first of all, who knows where they are? Who knows who they are or where they are? That's not going to happen this afternoon when you're looking for your emergency custody.
Well, then, if there's a true, I mean, one of the concerns that's expressed is, well, there may be danger to the children. If, in fact, this is a case in which DCF is involved, then DCF
Goes
has
into
its
court.
statutory right and duty to take charge of the situation
Yeah, but we
and
don't want,
protect
I
the
mean,
children.
we've seen the horrible results sometimes when DCF acts too slowly. And so you don't want to slow them down in getting into court because they can't get the person who actually has
No, but they
firsthand
can go in.
knowledge.
You're saying
They can go
this is not a DCF proceeding.
This is not a DCF
And
proceeding.
if the child is truly at risk, then DCF should be in court.
That's right,
If they've
Your
got
Honor.
reason to believe that the child is at risk, DCF should be there.
That's
now,
right.
they may not be able to get a temporary order.
That's right.
But,
And
but,
if
but,
the...
but it's
if-
your client's interest. You're the one whose client, I mean, your client is looking to get custody, who's making the argument that, for whatever reason, she thinks that her children are in danger. So she's the one who's going to be delayed because you can't get this stuff as fast.
As with any, I think as with any wrong practice, you sometimes may be on the right side of it, but the practice is still,
Yeah.
is still wrong.
Right.
Okay? So yes, the fact that I might have a client who at times benefits from it doesn't make a practice that is
I don't disagree.
constitutionally and statutorily wrong
Well,
the
I
correct
take
practice.
that your other argument is that some families are involved with the Department of Children and Families. Other families are not.
Correct.
Families that are not involved with the Department of Children and Families have to go into court because they think their children are threatened, and they have to produce whatever information. It can be hearsay, but it has to be reliable hearsay that they have to support the relief that they are requesting. There shouldn't be a category of families who happen to have involvement with the Department of Children and Families, where one or other side benefits or doesn't benefit from that.
Precisely, Your Honor. And
But why shouldn't the rule simply be that the judge is supposed to rely only upon reliable hearsay and leave it to the judge to decide in a case-by-case circumstance whether what he or she has is reliable or not? Why do we need to declare that all such information is unreliable per se, which is what you're asking us to do?
Well, I think I'm asking you to declare that information obtained through this process is inherently unreliable.
Okay.
Yes,
even,
but I don't.
Even if the information is simply that there's a report of the claim of abuse, and probation calls the probation office to say, I gather there was a claim of abuse. What happened? And the probation officer learns that there was no finding of abuse and reports that to the court.
I think that, I mean, the very bare bones of, yes, there was a 51A and it was, screened in or screened out, those are objective facts, okay? But once you get into the details and the underlying circumstances, then I think you have the great problem of selection and distortion to which the Chief Justice pointed a few moments ago.
Though, if we're looking at this case, and you say it was error for the single justice not to certify the class, and you want us to look at the 2007 protocol, right?
Right. Well, I want you to look at the 2007 protocol, whether you can, there are a variety
but
of...
let me just ask you this question
Okay.
on that. Forget the class then for a second. Your clients, as far as I can tell from this record, who are the named parties here, are neither in the probate court and certainly have never been affected by the 2007 protocol. And even if you make, so how do they become representatives of a class?
Well, because at the time when this case was commenced, they had just very recently been in the probate court. They were subjected to the practice, which remains fundamentally the same.
But we have no factual information about how it works now, correct?
Except for the not in an individualized basis, there is simply the stipulation, I think, in the record that it is, it is used in accordance with its terms. Okay. Thank you very much.
Thank you, Mr. Benjamin. Mr. Porter?
Good morning, and may it please the Court. William Porter, Assistant Attorney General for the appellees.
Mr. Porter, let me ask you this. I understand the very troublesome standing and class certification questions. If, and I'm not supposing that we will conclude, but if we conclude that notwithstanding the fact that this hasn't been promulgated as a rule, but as a practical matter, the 2007 protocol is being applied in the context in which, ex parte orders and 209As and so on. And if we conclude that there are serious problems, what do we do?
Your Honor, I think the best way to approach this issue, and the only way to effectively approach it, is to hear individual cases that are taken up if and when appealed.
What if it just inherently has problems with it? And just as the Chief says, that there's... You may not have the right parties here, but you read this and you see that inherent in it, let's just say, hypothetically, inherent in it are some significant due process issues. Are we just supposed to say, well, you don't have the right parties, so let it keep going?
Well, Your Honor, I would submit that if the posture that we're in is that we don't have parties withstanding and we have no evidence as to the application of the protocol, we simply have the document on its face, it becomes more a matter of judicial administration and less a matter, I think, or we would submit respectfully, that is amenable to a judicial outcome in a published opinion. When this case was filed...
Well, that may be, but then what do you suggest we do? Let's say we exercising our superintendency here.
Well, I think...
Let me ask you this. Is there any dispute that the 2007 protocol is being carried out in Hampden County?
No.
So it is being carried out. So
Yes.
somewhere there is somebody who has been subjected to the 2007 protocol.
Yes.
And the question is, you're saying, we haven't found that person, or if there is that person has no particular interest in litigating this all the way to the Supreme Judicial Court.
Well, we did check as I was preparing for oral argument, and none of the judges in the Hampden Division could identify any case in which the application of the protocol had been challenged. The plaintiff counsel, which practices regularly in Springfield and has a large client base, has not amended its complaint to add in the individuals who have been involved in proceedings under the protocol. And we would submit that, in fact, the essential structure of the protocol is fully consistent with due process, and that it can be applied and is being applied constitutionally, and that there would be
Do you know whether or not, I take it that, you're here representing the entire Commonwealth. Is this protocol being applied in Suffolk, Middlesex, Bristol, Essex?
There's nothing in the record on that, Your Honor, and this particular protocol is not replicated in other counties. I think it would be fair to say that that the problem that the protocol seeks to address, of course, exists statewide.
Well, how do the other counties deal with this problem, if you know?
Again, it's not in the record, but I think they deal with it in various ways. But I think the problem is there and has to be dealt with in the sense that an individual comes into court, often unrepresented, claiming there's an emergency situation, asking the judge for relief that day, or a child will be put at risk. The judge doesn't know whether to act on that request or whether to wait and try to get more information.
But that's true of any family, regardless of whether or not the family is had any, whether the Department of Children and Families has any involved with that child. And please don't tell me that only children and families where the Department of Children and Families is involved are the ones who are subject to grave injury, right?
That's absolutely
and in
correct,
fact,
Your
if
Honor.
anything, one could argue that if a family is in the jurisdiction of the Department of Children and Families, the DCF is keeping a pretty good watch on them and should be going into court if they think the child is at risk.
Well, I think that's actually one reason that the protocol exists. I know that the probate and family court judges think it's very important to know what is the status of DCF's involvement, if any, and is there an ongoing investigation? Is there a completed 51B investigation, for example, which would be independently admissible in any of a number of other types of proceedings? So there is
But
evidence
then you admit the 51B.
Right.
Yeah, then the question is, yes, no, has the investigation been completed? If yes, send me the report. If no, what do we do with that?
Well-
Somebody's filed a report, and DCF has made no conclusion about it. Are we supposed to use that against?
Your Honor, the protocol is intended to address a very limited category of proceedings, limited in time, where the court otherwise would risk being without any background information in order to protect the interest of the
you would agree
child.
that parties ought to have a right to rebut false information, erroneous information.
Absolutely, Your
So
Honor.
what's the
And that's-
problem with bringing the entire file in? There's a problem, correct?
The problem with that could be a resource problem. The problem with that could be that it provides more information
Yeah,
than
but
can reasonably be digested.
Well, then you've got some, and I have the greatest respect for the social workers and the others who work in the Department of Children and Families who do an amazing job, but you've got somebody who, on equally short notice, may not know this family, is flipping through the file, picking out what they want to, calling it over to a probation. Why don't you just send the file across?
Well, there's nothing to preclude that, Your Honor.
Are there any privacy rights of people
Yes,
who were
there are.
named
Sure,
in the
sure.
file?
There clearly could be, and that would be one problem with
And also,
providing information.
the judges in the probate court, I've never sat there, but I know they're very, very busy, and they don't want to go through a wad of papers like this.
Your Honor, when this case was filed, Chief Justice Dunphy told me in very compelling terms what it's like to sit on the bench, see a courtroom full of individuals appearing pro se who need their case decided that afternoon.
I know. I can also tell you I just testified before the Joint Committee that in, I think, this county, at one of the western counties, each judge has 4,375 cases assigned to him or her. Nobody questions that.
Right.
We have that throughout this Commonwealth, including DCF. But the question here is is this information reliable?
And that is a question that each judge will need to evaluate at each hearing.
How can you do that
Well,
without looking at the file?
to begin
I mean,
with, Your
if
Honor,
let me tell you, what I would do, and maybe this is, you're looking for the worst possible information because there's been a claim that a child is at risk. Why wouldn't you go through the file trying to find out if there's anything that will substantiate that claim?
It isn't necessarily that one-sided, though, Your Honor. Oftentimes, parties will want this information to come in because it will help substantiate their claim for custody, or that the other party wouldn't be entitled to custody. So it's...
I understand that, but we've got two parties. So not always, but almost always, if it's very helpful to one party, it's very hurtful to the other.
It depends, Your Honor. I don't think it's that black and white.
No, it's
But
not that black and white.
What we
I agree.
have is an infinite range of situations which could come before a probate and family court justice. This protocol just allows them the possibility of having some information which they can judge the reliability of themselves. The parties are entitled before the hearing to review the information. The judge...
They're not entitled to review the information. They are entitled to review the summary that has been culled of the
Exactly.
information. That's very different.
They're entitled to
And
review
what is,
exactly...
why can they only review and not obtain a copy? I mean, isn't that a little silly?
Your Honor, the whole thing is a balancing act, and the reason for that
What's
limitation...
the balance? Why can't they get a copy so they can have a copy and be looking at it in court if they want?
It's privacy, Your Honor. I think
But they've seen it already.
Well, I think it's a
Maybe
concern...
they made a note of all the names.
I think the concern is that, especially with pro se litigants, if information that otherwise should not be released because of privacy concerns is released, they treat it...
Well, isn't
I'm
that a
told the
little
way they treat...
Alice in Wonderland? It hasn't been released because they've seen it, but they haven't written, but they may write it down on a piece of paper.
Well, again, I think a lot of this reflects the difficulties on the ground in the probate courts because they want the parties to be able to see the information and respond to it. And the judge is seeing exactly what the parties see, no more. There is no extra record information.
But the judge can keep it with him or her. The
Excuse
judge
me?
has it. The judge has it. And the judge can keep it, and the judge can make her decision on it, right?
Yes, the parties can seek the release of the information later. It's treated the way a GAL report is treated. GAL reports, when they're filed in the probate court, are filed separately. They're noted on the docket. They're filed
Yes,
separately.
but you
They're
get the
impounded.
GAL testifies as well.
And the same could happen in these hearings, Your Honor. These are expedited matters, typically same-day matters, typically that allow only for temporary orders, short-term orders, where all the parties could come back 3, 5, 7 days later, and there could be live testimony.
Could I ask
So
you
these are situations that where the judge is trying to work with what he or she can get for the moment, and then bring in the parties as necessary, permit testimony 3, 5, 7 days later for a fuller adjudication. These are matters where the judge is trying to prevent harm that day. And that's why the information is gotten. The judge can assess its reliability. The judge can ask. This says you missed an appointment. Were there any other appointments, Ms.
Mr.
Maybe the
Brantley?
judge
the
doesn't
judge
think
doesn't?
to ask that. Maybe the judge doesn't think to ask that.
Well, I think we have to, with all due respect, Your Honor, trust the probate and family court judges to do what they're charged with doing, which is assessing reliability of evidence, making the best decisions they can, tailoring their proceedings to the dictates of due process, which varies in the
Mr.
circumstances.
Porter, may I ask you this? Is there anything, either in the record, I doubt it, but that would tell us of the number of cases that fall into this category to which the 2007 protocol applies or is being implemented? Ex parte motions for child custody, visitation, temporary custody, visitation, guardianship of a minor, very important case. Certain complaints for protection under abuse of 209A involving children. How many of those involve litigants where the family, one or other party, is already has some relationship with the Department of Children and Families as opposed to the remaining?
There's no statistical record here of the
Because
number
there's nothing
of...
about 2007, period.
The only thing about 2007, and this was the plaintiff's choice to litigate it this way, the only thing about the current protocol, the April 2007 protocol, is the document itself and the the stipulation that it's implemented as applied. So that's what we have, and that's why we would submit that when one looks at the protocol, sees that it's not a rule of procedure, it's not a rule of evidence, it's only an effort to get information in certain expedited proceedings.
If Justice Spina said, this is a rule of procedure, you need to submit it to this court, and then you move for reconsideration, and he said, okay, yes, you can promulgate it as a standing order, and then you didn't do anything, but it's in place. Isn't that a problem?
No, it's not, Your Honor. And just to complete the picture there, that was all exactly on track. In fact, he ordered that it be promulgated as a rule of procedure. The justices responded that it addresses such a small, discrete area that it wouldn't make sense to promulgate it as a general rule of procedure. May we do a standing order? He said yes, but he added conditions to that. In addition to the usual conditions for a standing order, which is simply review by the CJAM, he said this standing order should be submitted to the SJC Rules Committee. And so it was promulgated, it was put out in Lawyers Weekly, it was submitted for public comment was received, and then Chief Justice Carey, who had succeeded at that point, Chief Justice Dunphy, submitted it to Justice Graney as the representative of the Rules Committee. Some weeks later, he then sent it back and said that the Rules Committee would not take action on it and that instead it would be addressed in the context of this case. So they were trying to go the standing order route, and it was stopped short.
I see.
And that responsive letter is not in the record, but I can certainly provide it to this court. Sure. Here's the problem we have. Situations where probate and family court judges desperately need information. They have tried to, and I think succeeded, in promulgating a protocol that in its essential structure does comport with due process, can be applied constitutionally. I think we would submit respectfully there would be a grave danger if this court entered a sweeping restriction prospectively based on hypothetical situations offered by the plaintiffs that suggest that there's no way that this information can find its way in. I think addressing this...
Would you agree that if other counties are following a protocol that does not comply with due process, for example, they were doing what was done under the old protocol, that would be an unfortunate occurrence? Let's say in another county, they're not giving the parties an opportunity to see what the reports are or to rebut what's said?
Absolutely, Your Honor. I think it would be more than an unfortunate occurrence. I think in the single justice's memorandum decision, we have the essentials of the due process requirement, which now should absolutely be followed in all counties, even though that's not a published decision. The Commonwealth argued that the case had become moot when the April 2000 protocol was put out.
April 2007?
Yeah.
I'm sorry.
Yeah,
April
that's
2007.
No, I just wanted to put a new one.
Justice Spina nonetheless reached the issues under the prior protocol and addressed them. We haven't appealed, obviously, from that portion of the decision, so it's there, and it's certainly there as more than guidance to the other counties. It's there, I think, to be followed by the other counties.
Mr. Porter, let me ask you this. The 2007 protocol has a requirement that the litigants are required to disclose in an affidavit whether a DCF is or previously was involved with the party, I take it that's the litigant,
Yes.
or the children who are subject. And then the litigant indicates whether he or she gives permission to DCF. What happens in cases where, let's say you've got two parents and they both indicate that they may not be a family unit anymore, but they've been involved with DCF, and one says, I give permission, and the other says, I don't?
The protocol provides that the individual judge, in any case where he or she determines to do it, may enter an order for
No, I
release
know
of
that, but
information.
is it absolutely routine that if one party, one litigant says, yes, DCF can hand over the file, that then trumps the opposition, or do you then have to have a judicial determination if neither party gives?
Unfortunately, I don't know what's routine. The record is so spare in this
Yeah.
case. But if a party's consent could certainly provide for release of information referring to them or their children, I believe that's provided in the DCF regulations. If there's this conflict, I would assume that the judges would be safer if they thought they needed the information to enter an order, which would be allowed under sections
Do
51E and F.
Do they, when the judges enter an order in a situation where someone has refused consent, is there any discussion with the party that before the order enters, or does it happen before, the party has no idea that that's happening?
I don't believe there is discussion. My understanding is that the orders are issued, again, since this is an expedited process, that the orders are issued without a separate hearing on the question of the issuance of the order. So I believe that's how it happens. But
I think your time is up. Thank you, Mr. Porter.
thank you.
All right. Hearing